The utter incompetence and negligence of the other side, you just can't make this stuff up. I just peppered the hell out of them saying, where is this money? Where's the deposition? Kept my powder dry and I kept my mouth shut. Sometimes that's the best way. Hey, Brian Parker here with another exciting video. This is from the files of You Just Can't Make This Stuff Up. That's what I should title this. But I've given you a couple of videos on motion and compels, how to respond to a motion for reconsideration, what those things are. And embedded in those videos are my trials and tribulations with JP Morgan and their law firm representative, Mandarich Law. And I don't know how to put this. I'll put my opinion, the utter incompetence and negligence of the other side. It either goes to new lows or new levels. And the latest chapter of something that should have been gone a long time ago was their motion for reconsideration. So I'm going to show you at the end of this, it's a short video, the update of what happened and why you just can't make this stuff up. So as you might recall, I've got to do this. Like, love, and subscribe. Killdebt.com is there with the AI superpower of ParkerGPT. It does everything for your self-defense. Killdebt 2.0 is just around the corner. Hang in there with us. I'd rather have it done so it's almost perfect and have there be a delay. And once you get this, and everybody that's a member gets this without having an increased price or anything, once you see what we've done, you're going to be very happy, and it's going to help you further take on debt collectors, AI debt collectors, everything for your self-defense. Anyway, so I'm going to give you a quick chronology. I'm sorry if it's boring, I just have to set it up to get to this great ending that happened yesterday. So JP Morgan files a lawsuit against my client. So that's a creditor lawsuit. Those are difficult. We have to bring our A game to respond to those, and we're shooting for a good settlement as opposed to with debt buyers where you know they don't own the debt, so you just want to kill the debt. So we then responded. Let me just put that up. JP Morgan files a lawsuit against the client. February 28th, defendant, my client, files responsive pleadings. We have our pre-trial, Shazam, March 31st. Here's my first tip for you. When you have a pre-trial, say nothing. What do I mean by that? You're entitled to discovery. Depending on your state rules, it varies, but when you are granted discovery, that's what's called open discovery. You can do anything you want. You can send subpoenas, you can send a written discovery, you can do depositions. Depositions of people that you feel are relevant for your defense or to show they have no case. So you keep your mouth shut because a debt collector does not want you to do anything other than written discovery, because subpoenas and depositions screw their offense up, and it exposes their case and their clients to not only legal ridicule, but also the attorneys that are bringing these cases without really putting much care. Now I literally ask their client, how come you did this? And it's the stupidest thing that the attorney should have known better. Because I don't know, if I can have their client in deposition looking at them going, and just feeling like they're not represented properly, I've done my job and that case goes away. So they'll try to close me down and probably anybody else from open discovery. But say nothing, don't ask for it, because if it's just in your state, it's automatically open discovery. Keep your mouth shut, okay? If they start talking about written discovery only, now you got to speak up and say why you want it. So I kept my mouth shut, automatically I have open discovery. So immediately I sent a notice of deposition to the Mandarich Law, and I waited knowing exactly how they operated, and on June 4th, Shazam, the plaintiff emails me, and here put up the email, saying, hey, Mr. Parker, I'm filing motion to quash this deposition notice. The earliest hearing date is June 23rd, 2025 at 9 a.m. Consequently, your June 10th, 2025 deposition will not be proceeding. As I said in previous emails, as I've said in previous videos, there's really two ways to go about canceling or adjourning a deposition. That isn't either one of them. And here's how it gets better. We found out that they had never filed a motion. So they sent us an email, and that's important, saying, we filed a motion, so your deposition can't go forward. The two ways to do that is say, hey Parker, let's do a new date that's inconvenient, or two, I'm filing an objection to the deposition, and then it behooves me to go do what I have to do. They said they filed a motion, they never did. I called the court, and the court's like, what are you kidding? There's no motion, so they fabricated. So I filed a motion to compel and demanded they pay me $1,000. Attached to the video is the motion to compel, just for you can learn and educate yourself, and we'll put it into ParkerGPT. So the hearing went ahead, and guess what? JP Morgan's counsel failed to show, just didn't show. And this is quite common with this particular attorney and law firm. I'm just gonna tell you, that's what happens. So I know that. So the court ordered that I get my deposition in 10 days and I get $1,000 sanctions. Shazam, there's the order. And I then did what I'm supposed to do, was send the other side notice of the order, email, mail, FedEx, carrier pigeon, whatever it took, I got it over there to that person. And there's actually 3 attorneys I'm dealing with over there. So I'm in triplicate everything. So I cover myself, right? Because I know this firm. So they refused to pay, and they refused to set up the deposition, which was required to be done in 10 days. I just peppered the hell out of them saying, where is this money? Where is the deposition? I'm creating a paper trail, all right? So we eventually got paid in 30 days, and I filed a motion for default, seeking a dismissal and further sanction. So generally how it goes with discovery, you do a motion to compel discovery, an order is written. If they don't follow the order, in this case, provide the witness in 10 days, you then can say, well, they're not honoring discovery, and this is in the rules, most states, I want a default. Here's the attached motion for default I filed in Word. They filed a responsive pleading, a response to my motion saying, okay, we did receive his previous motion notice where he was awarded sanctions. He sent it to us by email. The rule is, he says, that you can't send us notice by email unless there's some agreement by the rules, which came out of COVID. Here, I'll show you what he said. Shazam. On or about June 25th, defendant filed a motion to compel deposition and award sanctions and served it upon plaintiff without notice of hearing. They're saying, I sent everything to them but the actual notice of hearing. Plaintiff counsel, this is the Mandridge law firm, admits defendant's counsel emailed a copy of the motion with the notice of hearing. However, the email service is not valid means of service under MCR 2.109. 2.109 is if you have an appeal going or you want to, or a final judgment, and you want to either do a motion for reconsideration, the other side files a motion for sanctions or bond. It's a bond rule. It's got nothing to do with email service between attorneys. So the court was having none of this because I pointed out to the court that this, I went in ChatGPT and it's the exact same thing that ChatGPT said and was wrong, and I showed the court, and the court said, case dismissed. This is a very rare thing. Case dismissed against JP Morgan, a creditor lawsuit, dismissed with prejudice. So the defendant, here's where it gets weird. Defendant filed a motion for reconsideration. Here's Shazam, my motion for reconsideration video that talks about this particular motion that was filed. And at that point, the hearing had not taken place. So this is where the you can't make this stuff up kicks in. The JPM counsel filed the motion, and they were telling the court, you were wrong in the way you filed this, and you didn't follow the rules. And here are the rules that JPM Morgan's counsel said, Shazam, plaintiff counsel admits that defendant's counsel emailed a copy of the motion with notice of hearing. However, email service is not valid means of service under 2.109. Again, they cited the wrong rule that ChatGPT, I clearly could tell, had given them. And they did it again to say the court was wrong, and they cited the wrong rule to begin with that had nothing to do with this case. So their defense is essentially saying, at the very beginning when Parker sought a motion to compel and money, which they paid late, but they paid, Parker gave us notice by email, but he didn't give us notice by mail that the rule requires because he hadn't followed 2.109. The rule is 2.107, and it's not even close to 2.109. And here they are under a motion for reconsideration, citing the wrong rule and saying the judge is wrong, because that's what you do in a motion for reconsideration. You say, judge, you screwed up. Rarely does that get granted. So if that isn't enough that they relied upon ChatGPT, I believe, citing the wrong rule in their first motion, got notice from me in the hearing and in my brief response that you use ChatGPT, it's 2.107. They filed the same thing under 2.109 again. If that isn't weird enough, here's the update. On the day of the hearing and after an hour, so you sit there in Zoom having to watch everybody's, for some reason my cases always get held last. I think because I kind of go deep and the judge needs time to read, but you got to sit there and watch. Oh yeah, he stole my cow and I want to get paid. Or hey, he sold me a car that doesn't work and the title, and I gotta sit there and it's kind of funny sometimes. So finally they get to me and they call JP Morgan's counsel. He doesn't show his own motion that he filed to turn around the motion to dismiss. A very important motion he's gotta file, especially if he's gonna appeal. He did not show to his own motion. JP Morgan failed to show, their attorney failed to show on the day that they set the whole thing to go down. Now, I at that point had a right to say, are you kidding me? So I said, when this happened to the judge, I go, are you kidding me? And he just shook his head and he said, this thing, and he dismissed it with prejudice because these things, these ugly things keep showing up, but this should do it. So here's a copy of the order. Now, if they're gonna appeal, they're gonna be hard pressed to show not showing up and filing the wrong court rule again and again is the basis of appeal. So this case should be done. That's the update to that case. This is Mandridge Law, who represents a big client, JP Morgan, and that is a commonplace. It does not happen that much, but that particular attorney does not show things. And this argument they made on behalf of JP Morgan, using the same wrong argument and then accusing the judge of screwing up, is how they are being represented, how Mandridge Law is representing JP Morgan. I'm saying that as a fact that I have experienced. Everything's in writing, and I've talked to other attorneys and they have similar experiences. Maybe they're overworked, God bless them, they've got a lot of work, but they just lost a case that they themselves created the loss. It's rare to get a dismissal with prejudice, and he may have had a chance of turning it around because judges don't want to dismiss things with prejudice unless they absolutely have to. And I had done the work, and that's what you need to do. Leave a paper trail, register by mail, document everything. I did it in abundance, but I could not predict that they would just not keep showing up. I could have asked for fees, but what had happened, if I'd asked for fees, then that would be appealable, and now I'd see another motion for reconsideration, because let's say I asked for 1,000 and they say, hey, he shouldn't have got that and he screwed up and blah, blah, it would have kept going. So I kept my powder dry and I kept my mouth shut. Sometimes that's the best way. So I hope this update is fun for you. You just can't make this stuff up. Thank you.